Karnataka. He has already taken few sessions on our platform, and we all discuss about the Employees Compensation Act in the ordinary parlance and the interplay between the Employees Compensation Act and sometimes when we file a case before the Motor Claims Tribunal. A lot of issues before we were going live. We were talking to Mr. Ramanath. He unfortunately met with an accident, but God was kind enough that he was safe. These all issues, not only as a lawyer one has to learn, but a common man also has to learn. As such, this topic, I would feel even the employer's perspective, that is the firms, companies, etc., would also be benefited from this process. And without taking much time, I would request Mr. Angadi to share his insights on an important and pivotal topic. Over to you, sir.
Thank you, Mr. Vikas Charath. I wish all the viewers a happy Father's Day. To begin with, the name of topic is very vast. Employees Compensation Act, Case Law of the Apex Court. The topic is very vast. In 1 hour, I will complete the most important judgments of Supreme Court of the recent period or recent decade. To begin with, as you all know, many of the advocates, they apply the principles of Motor Vehicles Act, or they apply the ratio of the cases of the Apex Court or of High Courts in the context of laying down law on the provisions of Motor Vehicles Act in the context of Workmen's Compensation Act also. This act is now present as Employees Compensation Act from 2010. So whether can we apply the analogy of the case law of the Supreme Court on the aspect of Motor Vehicles Act and its provisions, vis-a-vis while applying the said particular law of the motor vehicles in the context of the EC Act? That is the first question. The second point is, in a Motor Vehicle Act matter, interest on amount of quantum of compensation is payable from the date of filing of the claim petition for grant of compensation. Whether the same rule holds good while granting interest from date of filing of petition under section 4 of the EC Act or not. On what date the court must award interest? Date of petition, date of order, or something else. That's also a very important fact, wherein many judges also render wrong judgment in stating the date from which the interest is payable. The third point is what is called as venue of proceedings. Say an employee suffers a death and is legally, say, were residing formerly, say, at Nagaland. After death of the son, the daughter-in-law and the parents of the deceased, they shift from Nagaland to Karnataka. And they are here only for the past 1 week. Can they file here at Bangalore a petition for grant of compensation under the EC Act or not? Only for 1 week they are at Bangalore, and for the previous so many years they were residing permanently at a place in Nagaland or some other state. What is the aspect of the law on the point? The next point is to sustain a claim for quantum under the EC Act. The important point is the accident must arise in the course of employment of the employee under the employer. Maybe a driver of a goods truck, maybe an employee in a factory. And the main point is there should be accident and there should be injury or death as the case may be, and it must arise out of and in the course of employment under section 3 of the Act to maintain claim under section 4 of the Act. So, for example, a case wherein a driver of a truck or a mini truck on en route to the place of delivery of the goods, it being very sultry, say at about 12:30 in the afternoon, he sees water flowing from the canal of Yamuna river. He just halts the vehicle, fills the can for the particular vehicle if required, and because it was hot, he goes there to take bath adjoining the particular Yamuna canal water. And thereby he slips by accident. He dies. The legal heirs of the deceased employee approached the forum commissioner for workmen's compensation. He said that the petition is not maintainable because on account of fault of the driver in taking bath en route, he died. The matter goes to the High Court. High Court also confirms the order of the trial court. The matter goes to Supreme Court of India. Whether the claim in this case is liable to be paid or not is the question before Supreme Court. So like this, we can jot so many important principles which the Apex Court has laid down from time to time. And with this, I will start now quickly the aspect of Employees Compensation Act of 1923. This act was amended in 2010 and the word workmen's was deleted and the word employees was added, and now it is called as Employees Compensation Act. And the year is same, and that is as per amendment in 2010. This act is a special act having a very few sections. They are less than 40, and we have got 4 schedules: Schedule A, Schedule B, Schedule C, and Schedule D to the EC Act. And Section 2, Subclause B of the Act defines who is called as a commissioner for workmen's compensation. And Section 2C defines the word compensation. Section 2D defines who is called as a dependent. So, wife of deceased, father of deceased, son of deceased, they are given a list. The next point is 2DD of the Act that defines who is called as an employee. So, I got a big list of 49 persons who come within the net of the word employee. So, employee to claim money from the employer by a petition before the workman's court, he must fall in the category of 1 out of the said 49 list of employees. 2 is what's called as meaning of employer, and 2F is meaning of minor less than 18 years. Then 2G is meaning of partial disablement, and 2I is meaning of qualified medical practitioner. 2G is meaning of partial disablement. 2L is meaning of total disablement, a case wherein the employee cannot work at all, and it is a case of total loss of earnings. And lastly, what is called as wages. Whether wages also includes the TA paid by the employer to the employee every day for commuting from his place of residence to the place of office or place of the factory. Then 3 speaks of employer's liability to pay for compensation in case of death or injury to the employee which arise in the course of employment of the employee with the employer. 4 speaks of how to arrive at the amount of compensation. 4A speaks of when the employer shall pay what is called as penalty and interest for default in not paying the amount of quantum of compensation which admits within 30 days from the date of accident or 30 days from the date of serving of notice on him by the employee. Then comes, section 21 of the Act that speaks of venue of proceedings, where the claimant shall file the petition before the commissioner for grant of compensation. Then comes other things. Time limit for disposal of cases is only just 3 months. Act gives time of 3 months only for the commissioner to dispose of the petition. Then 28 speaks of registration of agreement of settlement or compromise between the employer and employee in case of injury to the particular employee, or in case of death, the legal heirs agree with the employer for a amount, and that is 28 of the Act. Then 29 is effect of failure to register agreement. Agreement of payment of amount as the settlement to be registered, failing which each is void in law. And the employee or legal heirs of the employee can maintain action before the commissioner for workmen's compensation. We got Schedule 1 to the Act that speaks of list of injuries which are deemed to be permanent, list of injuries which are deemed to be what is called permanent partial disablement. So they are given percentage of disability depending upon nature of part of the body of a person. That is Schedule 1 to the EC Act. Then comes Schedule 2, Schedule 3, and Schedule 4. I will just skip it. And to begin with, we'll take now the first point. The first case law of the Apex Court of last year is 2020, Part 4, SCC, page number 594. The case name is what is called as K. Sivaraman versus P. Satish Kumar and another. The case name is namely K. Sivaraman versus P. Satish Kumar and another. This case pertains to the order passed by the Commissioner for Workmen's Compensation at Madurai, order of High Court of Chennai, French at Madurai. Then the matter went to the Supreme Court of India. In this case, the question involved for consideration before the Apex Court was namely whether benefit of Amendment 2, the EC Act, enhancing the amount of compensation or enhancing the minimum wages from rupees 4,000 per month to rupees 8,000 per month as an amendment in 2010, whether the tribunal or whether the High Court or whether the Supreme Court can give to the employee benefit of the amendment provisions of the EC Act, even prior to the date of coming to force of the provisions of amended provisions of the EC Act. So in this case, the Supreme Court of India held that benefit of Amendment 2, the EC Act, is always prospective. It is not retrospective. In this case, the Apex Court held that the employee cannot seek for payment to him of compensation by reckoning the minimum wages from rupees 4,000, which was previously prior to 2010, to table to rupees 8,000 rupees per month as an amendment in 2010, because the Apex Court held that interest is payable on the amount of compensation from the date of accident and not from the date of filing of the claim statement. So in this case, the Apex Court laid down in very clear words that the particular, in this case, the upper court held that the High Court of, High Court bench at Madurai erred in giving effect to the amendment to the AC Act of 2010, and it held that benefit of amendment to the AC Act is always prospective and it is not retrospective. This is the ratio of the case of K. Sivaraman versus P. Satish Kumar. In this case, one Dinesh Kumar was driver of a lorry. He suffered an accident and he died in the accident. The date of accident is 31/1/2008. The act was amended in 31/5/2010, by which the wages being minimum was enhanced from rupees 4,000 rupees to rupees 8,000. So during pendency of the appeal before the High Court at Madurai bench, High Court of Madurai bench gave effect to the amendment to the provisions of EC Act and enhanced the amount of quantum by double the amount of quantum given by the Commissioner for Workmen's Compensation. The Supreme Court held that the approach of the High Court is wrong in law because the liability of the employer or insurance company to pay the amount of compensation will arise from the date of accident and not date of filing of petition or date of passing of order by the trial court or by High Court or by the Supreme Court of India. So this case of Sivaraman states very clearly that the benefit of Amendment to the AC Act is prospective and not retrospective. And in this case, the Appellate Court held that even though the provisions of EC Act are beneficial and it is a social welfare legislation, but still we cannot award payment of quantum of compensation by giving a retrospective effect to the amendment to the provisions of the EC Act. So the Appellate Court held that the date to pay the amount of quantum will be reckoned from the date of accident and not from date of filing of petition or from the date of filing of date of passing of order. So the date from which we to pay the amount of interest on the amount of quantum is from date of accident. I filed last year a petition for compensation. Accident took place about 3 years ago. So from 3 years ago, the date on which the accident occurred, the court shall award what's called as interest. That is the principle of law in the case of Sivaraman versus Satish Kumar. So with this, I have covered the first decision of the Supreme Court. In this case, the Supreme Court held that under Railways Act, interest on the amount of quantum is payable from date of filing of petition and not from date of accident involving the use of railway. In a motor vehicle case also, as you all know, court awards interest from date of petition and not date of accident. Whereas as per the EC Act provisions, as per the Supreme Court of India decision of the previous year, the Appellate Court held that interest is payable on the amount of compensation from the date of accident and not date of filing of the petition. The second case is Pratap Singh Narayan Dio versus Srinivas Sabata, 1976, Part 1, SCC, page number 289. Supreme Court in the first case of Sivaraman applied the ratio of this Pratap Singh Narayan versus Srinivas Sabata. In that case, the apex court held that liability to pay the amount of quantum will arise from the date of accident to the workman, but not from the date of filing of the petition. In this case of Pratap Singh Narayan versus Srinivas Sabata, the first respondent Sabata was a workman working in two cinema halls owned by the employer. He fell down from a height while working on some ornamental work of some furniture. He was severely injured. There was amputation of left arm from the elbow. A carpenter, he fell down while working in a cinema hall, working on some furniture item, and he suffered what's called as loss of left arm from the elbow. In this case, the apex court held that it is a case of 100% loss of earnings. So he is entitled to full 100% loss of earnings, and the apex court held that in this case, the amount to be paid is from date of accident and not from date of filing of petition. And in this case, the apex court further laid down the point that within 1 month from date of accident, the employer shall pay to the employee what's called as the amount of quantum as per Schedule 2 the EC Act, when in which the apex court held that the employer shall be liable to pay penalty up to 50% of the amount of compensation. So this case of, Sabata case is a case of authority. It's a case of judgment of 4 judges of the Supreme Court. This ruling the apex court followed in the first case of Sivaraman. So every employer shall pay to employee the quantum which he admits within 1 month from the date of accident or within 1 month from the date of receipt of notice by the employer. If not, he must have sufficient cause or explanation to postpone the payment. If not, he shall pay what's called as penalty up to 50% of the amount of quantum. That is the case of Sabata case. So with that, the next decision which I would like to touch is namely Arun Kumar Jha JHA versus Ranveer Singh and another. With the case of 2019 part 17 SCC page number 670. A case of previous year, the apex court in Arun Kumar Jha versus Ranveer Singh held that we had to do prospective operation of amendment to the EC Act. But this is a decision of 2019, but in 2020, in the case of what's called as case Raman versus Satish Kumar, the apex court held that it is always prospective in nature. In fact, the decision of Arun Kumar Jha was not brought to the notice of the Supreme Court when judgment of Supreme Court was rendered in 2020 part 4 SCC page number 594, that is K. Sivaraman versus P. Satish Kumar. So with that, the next important point is what's called as the case of the Supreme Court of India, that is Oriental Insurance Company versus CB George and others. It's a case of apex court, that is 2012 part 12 SCC page number 540. In this case, the apex court held that interest on the amount of compensation will be payable from the date of accident and not filing of date of the claim statement. or as on the date of passing of order by the commissioner or by High Court or by the Apex Court. So interest or amount of quantum becomes due and liable from date of accident and not date of filing of the claim statement by the employee. The Apex Court held that under Section 4, capital A, subclause 3 of the AC Act, the court can impose penalty up to 50% of the amount of compensation if the commissioner is satisfied that there is no justifiable cause for the employer to make delay in depositing the amount of compensation. The Apex Court held that before the court intends to inflict penalty on the employer, the court shall issue to the employer what's called as a show cause notice, call for his explanation, and ask him why he could not pay or deposit the amount of quantum as per schedule. If cause shown is proper, the court can waive what's called as penalty. If cause shown is not proper, the tribunal or the court can levy penalty up to 50% of the amount of compensation. So the case law of the Apex Court in what's called as Oriental Insurance Company versus CB George. With that, the next important point which I would like to touch is the case of North, that is Sabera Bibi, Sabera Bibi, Yaqub Bhai Sheikh versus National Insurance Company, 2014, Part 2, SCC, page number 298. Here also, the Apex Court held that interest at 12% is payable from by the employer to the employee. The next point is namely Northeast Karnataka Road Transport Corporation versus Sujata, the case of 2019, Part 11, SCC 514. In this case, the facts are very interesting. Driver of bus of the state of Karnataka died on duty on account of chest pain and suffered heart attack. So, driver of bus, while driving the bus and on duty, suffered chest pain and he suffered heart attack and he died thereafter. In this case, the commissioner allowed the petition. The matter went to the High Court. The matter was taken by the insurance company to High Court. High Court was required to raise a substantial question of law under Section 30 of the AC Act. This question was not raised by the High Court in the appeal filed by the insurance company. So the Apex Court held that appeal by the person aggrieved by the award passed by the commissioner is not an appeal under Section 96 of the CPC, first appeal, but there should be a substantial question of law, and court must frame that point of law before admitting the appeal filed by the aggrieved. So the Apex Court held that interest is payable from date of accident and not from date of filing of the petition. So with this, I have touched the aspect of amount of quantum to be paid from what date, that is date of accident. Number two, court cannot give benefit of provisions of the AC Act as per Amendment Act. It is always prospective but not retrospective. Payment to be made by the employer within 1 month from the accident date, wherein which he shall pay penalty to the employee. That is the third point which I discussed. So this, the next important heading is what's called as notional extension of in the course of employment. So what is called as notional extension of in the course of employment? Here I got case law of Supreme Court of India. Poonam Devi versus Oriental Insurance Company. 2020, part 4, SCC, page 55. In this case, as I told, driver of a mini truck, Tata 407, was on duty with goods to be delivered at some express. So on the way at about 12:30 afternoon, he stopped the mini truck adjoining the road by seeing the flowing of water from the canal. So he saw Yamuna canal and saw water flowing, and it was, afternoon. He stopped the vehicle on a safe side, got down the canal to fetch water in a can, and he took water in a can, and thereafter he just thought, I'll have a bath. He had bath, and by taking bath, he slipped by accident and he died. The legal heirs of deceased filed petition before the Commissioner for Workmen's Compensation. The Commissioner allowed the petition, holding that accident occurred in the course of employment of the deceased. Even though he died while having bath, but still it is in the course of employment, the Commissioner allowed the petition. The insurance company appealed to the High Court. High Court passed order holding that the driver was at fault in taking bath en route by seeing water of Yamuna Canal. And the High Court passed the order holding that employer or owner of truck, you pay the amount, absolve liability of the insurance company. Thereafter, the legal heirs of the employee appealed to Supreme Court of India. The question is whether the insurance company is liable or not. The question before the apex court was whether the insurance company is liable to pay the amount of damages because the driver died not by driving the truck, but he was en route to some X place to deliver goods, and here in this case he took bath by seeing water of Yamuna Canal. The apex court held that death of driver in this case is in the course of employment, and even though he died by slipping by accident while having bath in the water of river, the canal Yamuna, the apex court held that he died in the course of employment of the particular employer. In this case, the apex court held that taking bath by the driver was required because it was hot sun in the month of first week of June of a given year. The Supreme Court Googled, and on the given date of accident, this man died, the temperature at the place was 42 degrees centigrade. So the apex court held that he took bath to become fresh so that he can drive further to deliver the goods at the other end of the destination. And the apex court held that water was required for the vehicle because it is a old vehicle and non-AC vehicle. And the apex court held that there is the theory of notional extension of in the course of employment, and held that even though this man did not drive by driving the vehicle, but he died on account of taking bath, the apex court applied what's called as notional extension of in the course of employment, and confirmed the order passed by the commissioner, and observed that High Court was wrong in allowing the appeal filed by the insurance company. So the apex court held that the theory of notional extension of in the course of employment applies to the facts of the case on hand, and it added that the claim is maintainable. With that, the next case on the same point is Leela Bai versus Seema Chavan, 2019, part 4, SCC, page 325. In this case, the facts are interesting. Driver of a bus, his duty was over by 7:30 p.m. His next shift was next day morning at 6:30 a.m. This driver boarded on the roof of the bus to take his dinner. He had with him the lunch box. He went on the bus's roof or top. There he had his food, and while climbing down from the ladder of the bus, he slipped, he fell down, and he had head injury. He died. So, driver of bus, duty was over. He had food on the bus stop or rooftop. While getting down, he fell down, and he died on account of severe head injury. In this case, the wife of the deceased approached the commissioner. Commissioner held that accident occurred, but not in the course of employment. The commissioner dismissed the claim of the legal heirs. The matter was taken to the High Court. High Court also confirmed the order of the trial court. Then lastly, the claimants approached the apex court by filing the appeal. The question is whether the petition is to be allowed or not with the main question. The apex court in this case held that the principle of notional extension of employment applies because in this case, this driver had duty next day morning at 6:30 a.m. And with that point in mind, he wanted to be in the bus only at night and was to sleep in the bus only during night hours so that in the morning he has to start the bus at 6:30 a.m. The bus court held that in this case, the accident occurred in the course of employment, even though the bus was stationary and even though the driver died while having food and while climbing down from the ladder of the bus after he had finished his food. So the bus court in this case held that this driver was at the bus stand and on the bus on the given day and time for purpose of reporting his duty next day morning at 6:30 a.m. So with that, I've taken also the case of the Supreme Court of the second important aspect of notional extension of in the course of employment. So let this again multiply. I'll tell only one more case. Manju Sarkar versus Mabish Mia 2014 part 14 SCC page 21. In this case also driver of truck because of vehicle's trouble of mechanical nature stopped truck and was going in the midnight at about 1 a.m. to fetch a mechanic to get the truck repaired. While going on the road to fetch a mechanic, some other truck came from other side in a great speed and driver dashed the truck to this man, the driver of the truck, which was halted on the road because of want of repairs, and that person died on account of rash driving of driver of some other vehicle. The apex court also in this case applied the principle of notional extension of employment and allowed the petition. The next case is Daya Kishan Joshi versus Dynamic Systems Limited. That is 2018 Part 11 SCC 642 Here also, the best court held that the principle of extension of employment is applicable and allowed the claim petition filed by the legal heirs of the deceased. The next segment is what is called as registration of settlement of claim by the employer with the employee. Employee suffers injury. The employer says, I'll pay you 1 lakh. They make agreement. They make compromise. And he pays amount in cash. And agreement is signed by both sides. And then after, what happens? The same employee approaches the commissioner for grant of compensation for the amount of quantum as per the schedule. There, the employer produces a copy of agreement or settlement or compromise between both parties, under which he had paid rupees 1 lakh by cash as compensation, and that the matter was compromised out of court, out of the tribunal. So here the case is Kuldeep Singh versus Panna Lal and another. That is 2016 part 16 SCC page 759. In this case, an employee suffered injury and the employer and employee, they rather compromise matter out of court. But still, the employer approached the court, the commissioner for compensation. The commissioner allowed the compensation, holding that this agreement is not before us being recorded, and the commissioner allowed the petition. The other side went to the High Court of Punjab and Haryana. High Court of Punjab and Haryana reversed order of the commissioner. It held that the matter was compromised between both parties and there is agreement, and dismissed and allowed the petition, the appeal filed by the insurance company, and dismissed the claim filed by the petitioner. The claimant went to Supreme Court of India. The first court held that this settlement agreement was not registered by the employer with the commissioner for workers, employees compensation under section 29 of the EC Act. The first court held that this agreement was not registered before the commissioner as per law, and held that the employee is to be paid the quantum as ordered by the commissioner, and restored the order of the commissioner and set aside order passed by the High Court. So here the ratio is any agreement of compromise between the two parties must be recorded before the commissioner for workmen's compensation, wherein which it is void ab initio or section 28 of the EC Act. So with this, the next segment is functional and physical disability assessment. How to assess what's called as disability, namely functional versus physical. So here we got the case law of Supreme Court, that is 2020 part 1 SCC page number 796. That is Chennappa Nagappa Mochala Oda versus New India Assurance Company Limited. So in this case, it is called as a case wherein there was disability of driver. Here, driver of a truck suffered injury to right leg by an anterior cruciate ligament and a collateral ligament tear. So in this case, this driver was unable to drive the vehicle henceforth. So the injury was injury to right leg by an anterior cruciate ligament and a collateral ligament tear. In this case, the first court assessed the functional disability at 100% and modified order of the High Court. So even though as per schedule to the EC Act, it is quite less, but still the Supreme Court scaled up to what's called as what is called as 100% and awarded to him the full amount of what's called as compensation. Next is S. Suresh versus Oriental Insurance Company Limited, 2010 Part 13, SCC, page 777. Driver of truck lost control over the vehicle and the truck overturned, and there was his right leg was amputated below knee. Right leg of driver was amputated below knee because of injury in a motor vehicle accident. The apex court held that there is 100% physical disability and awarded him full amount of compensation. The next point is Paul Raj versus DC NEKRTC. That is 2010 Part 10 SCC, page 347. In this case, driver of bus suffered accident. He was injured. He suffered 65% disability of the whole body. And here, the driver was given the job of a peon in the department. So, a driver of bus not fit to drive the bus henceforth because of disability was given the post of a peon in the corporation of the bus. In this case, the bus court held that the disability is 35% and scaled down the amount of quantum. So with that, the next point is that is Sheikh Osman Ali Chaus versus New India Assurance Company Limited, 2018 Part 3 SCC, page number 49. Driver of truck suffered loss of fourth toe and fifth toe of left foot, and there was loss of grip of right hand. He was unable to drive the truck in future. The Supreme Court held that there is a loss of earnings up to 70% of his earnings per month. Then one more case is Basappa versus Basavaraj M. Tuppada, 2018 Part 13 SCC, page number 598. In this case, driver of truck lost one eye in the accident. Driver of truck lost one eye in the accident. The apex court held that the loss is total loss. So to award in that case, what is called a full loss of earnings as the entire amount of quantum. Next is Ire Gowda alias Vasu versus DM. That is the 2018 Part 15 SCC, page number 246. So a ratio of the same type. Then Nagarajappa versus DM, Oriental Insurance Company, 2011 Part 13 SCC, page number 323. So I will not take much time to tell you how the Supreme Court awarded quantum based on functions of the particular limb of the employee, even though the Schedule 2, the EC Act may prescribe lesser percentage of loss of earnings. So Supreme Court of India, in many cases, deviated from the percentage of schedule as per EC Act, but scaled up and awarded more amount of quantum depending upon the aspect of functional disability vis-a-vis physical disability of a given person. Next case is there is an employee was insured by the employer under provisions of what's called as ESI Act. Employee was insured by the employer under the provisions of Section 53 of the ESI Act of 1948. So in this case, an employee who was insured with the ESI authority was injured in an accident. He filed petition before the Commissioner for Workmen's Compensation. And here the Supreme Court of India held, in case an employee is covered as an insured with the ESI, then the claim before the Commissioner under the EC Act is not measurable. You have to approach that forum only for grant of the amount of quantum, because there is a coverage of insurance by the employer under the provisions of ESI Act. So no claim before a workman's court will lie by an employee who is covered under the provisions of ESI Act, because he is said to be an insured person under Section 2, surplus 14 of the ESI Act. So that the next point is contractor and subcontractor, principal or contractor relationship. That is the case of Fazlur Rahman Ansari versus National Insurance Company, 2019, Part 13, SCC, page number 806. A contractor got some contract work from government. He employed subcontractor and gave him some work for doing. That subcontractor employed an employee. That employee died. And the legal is filed petition against the main contractor and not subcontractor. And the main contractor submitted that I am not liable because the deceased was the employee under the subcontractor to whom I sublet or subcontracted my contract. But the Apex Court held that in case of a contractor and a principal, or in case of a contractor and subcontractor, the contractor or principal employer is liable for the act of his contractor or subcontractor, and the Apex Court held that there is a relationship of employer and employee between the employee and the subcontractor, and the Apex Court held that the employee can maintain a petition against the principal or the main contractor, even though that particular person was employed by the subcontractor and under whom he worked at the relevant point of time. So the case of Fazlur Rahman Ansari states that a subcontractor is liable to the main contractor, but the employee can file case against the principal or the main contractor and recover the amount of quantum of compensation. Next case is namely Bappu Mian versus New India Assurance Company, 2018, Part 12, SCC, page number 591. In this case, a cleaner of a truck was helping the driver of a truck while the driver was taking the vehicle in the reverse direction. While he was helping the driver of truck to take the truck in the reverse, this cleaner by accident came in touch with a live electric wire of a pole which was hung, and it died on account of electrocution. The Supreme Court held that this man died in the course of employment. So with this, the last question is namely whether murder of a driver on duty by somebody else and death of the said man on account of murder, whether legal heirs of the deceased person can approach the court RISI Act for grant of quantum or not. That is, Palvinder Kaur versus Oriental Insurance Company, 2016, part 13, SCC, page number 317. Murder of driver of a truck on duty by some unknown persons. So they stopped the vehicle and they just murdered him. I don't know the purpose for which he was murdered. And in this case, the apex court held that the death occurred by murder while this driver was on duty and in the course of employment. So, murder of a driver on duty, and if the murder is, what's called as a case while he was on duty, the apex court held that the claim is to be allowed. In this case, the commissioner had allowed the petition. The High Court had dismissed, had allowed the appeal filed by insurance company, and in the appeal filed by the claimant to the Supreme Court of India, the Supreme Court of India held that in case of death of an employee by murder also, the claim is maintainable. That is the case of the apex court of a recent origin. So with this, I have completed in brief the case law of the apex court on the aspect of on various aspects, and there is Amendment 2, the AC Act on 3rd of January 2020. So, as per Amendment 2, the AC Act on 3/1/2020, in case any employee was earning less than rupees 500 rupees per day, as per the Amendment 2, the AC Act, from 3/1/2020, the minimum wages is fixed at rupees 500 rupees per month. That is rupees 500 rupees per month is the minimum wages as per the Amendment 2, the AC Act from 3/1/2020. So in cases where the wages claimed by the employee is more than 500 rupees per month per day, and on account of there will be no documentary evidence, the court can compute the minimum wages at rupees 500 per day as per the GO of Government of India dated 3/1/2020. So that is the latest GO of the central government, which states that the minimum wages per day of employee for the EC Act is rupees 500 rupees per day. That is the Amendment 2, the Schedule 2, the EC Act from 3/1/2020. So with this, I have completed the aspect of the latest case law of apex court. I have told you what the law is, what are the important niceties. Interest is payable from date of accident and not date of filing petition. Benefit of Amendment to the AC Act is prospective but not retrospective. One more point is employer to pay to the employee the amount of quantum within 1 month from the date of accident, failing which he shall pay what's called as penalty up to 50% of the amount of quantum. Interest is always at 12% per annum. Court cannot grant less or more, but it is 12% per annum as per the EC Act. So they are the important things. I also told you what's called as notional extension of in the course of employment. The case law of the Supreme Court. I've touched the aspect of the EC Act, the aspect of murder vis-a-vis EC Act, and also other things regarding quantum with regard to permanent disability cases. So this, if the viewers have got any question to be asked, I'll be glad to interact with them. It is a very act which is very technical, and we had to spend more time to get empowered on the aspect of EC Act. When many judges, they were violating orders at the trial court level. Sometimes they award interest from date of petition and not from date of accident. And I think these inputs will assist the advocates. And I'm very sure that I've given you the case law of the Apex Court of the previous decade, or also starting from 2001. If you got any doubts or any clarifications, I'd be glad to answer.
Yes, sir. This says by Ramu, can a cab driver meeting with an accident with another motor vehicle claim compensation both under the Motor Vehicle Act as well as the Employees Compensation Act?
So here the question which Sri Vikas has touched is choice of forum, whether before the Commissioner for Workmen Compensation or whether before the MACT under the ME Act. Or the question is whether a petitioner can claim amount of quantum under the both forums, MACT or ME Act, and also the Employees Compensation Court under the EC Act. And there we have got a case on the point that is called as doctrine of selection. The case name is Oriental Business Company versus Damawa 2013 part 9 SCC page 406. In this case, the Apex Court held that an employee who suffered injuries in a motor vehicle accident involving a motor vehicle has got the options to approach MACT or ME Act or approach the Commissioner against his employer and claim amount as per the schedule to the EC Act. But he cannot apply and get the damages from both the forums for one accident, for one injury. What law says? Claim either before the MACT or claim before the Commissioner under the EC Act. But he cannot have both remedies in parallel and recover from both the forums separate sets of quantum, one as per schedule, one as per case law of the ME Act. That is Oriental Business Company versus Damawa 2013 part 9 SCC page number 406. Choice of forum, MACT or EC Court, doctrine of selection. Employer or workman suo motu depositing compensation before the workman's court, whether workman can still file claim before the MACT. Apex Court held no. The employer paid before the Commissioner the quantum as per schedule. He withdrew it, then he filed petition before the MACT for grant of quantum under the ME Act. The Apex Court held that he cannot maintain petition under the ME Act. That's called as doctrine of selection. Yes, sir, because I think I have made it clear.
Can the precedents of the Employees Compensation Act be applied to motor vehicle cases?
I told in a Motor Vehicles Act, we award interest from date of filing of petition. Under EC Act, that is date of accident and not date of petition. As per Railway Act, date of filing of petition and not date of filing the date of accident. The ratio is the first case which I quoted, that is Sivaraman versus Satish Kumar 2020 part 4 SCC page number 594. Apex Court held pay the amount of quantum under EC Act from date of accident. On that day, the employer becomes liable to pay to the employee what's called as the amount of compensation. So, ME Act principles, here I told you the 4 or 5 areas In those areas, there are no application. So the case law is the first case, 2020 SCC part 4, page number 594.
If the worker dies due to accident happening due to an intentional act of a co-worker, then is the employer responsible for paying compensation?
Accident occurring on account of fault of co-worker. So, I mean,
intentional act, not the act.
Co-worker injures the driver.
Deliberately or intentionally.
Okay. If the co-worker, if the co-worker and this driver, they had enmity previously, and if this driver anticipated that the co-worker may cause him death, then he knew that he will be injured. In that case, the claim is not maintainable. That depends upon facts of each case. And we got here a plethora of case law of the Supreme Court of India and decisions of the high courts in our country. And to begin with, we got case law of Srimati Rita Devi versus New India Assurance Company Limited. This is a case of 2005 Supreme Court. Here in this case, there was murder of a person by a co-passenger. But here for your case, the co-employee caused death of the employee of the employer. And if the death is on account of accident, okay, claim is maintainable. If it is a case of murder or for gain, and if this particular employee, or if there was the aspect of that man anticipating the aspect of any unlawful or overt, then what to say the fact of each case. And further facts, as I told right now, intention on the part of the co-worker to cause death, if it is there, means the claim before the EC court is not maintainable. Murder of the co-employee by his other co-employee for gain or for enmity. In this case, if the factory itself he is murdered, then the employer is not able for compensation, even though death occurs in the factory, because the murder is for gain by the co-employee. That is, I mean, for the facts which are told, I am giving the answer.
Is the appeal maintainable at the instance of an employer without depositing the amount awarded by the commissioner?
Yes, sir.
He says that, is it appeal, Anurag Jain says, is it, can you file an appeal without deposit of the amount awarded by the commissioner?
Okay. So this is a very good question. The employer or insurance company suffers order at the hands of a commissioner. The commissioner allows the petition, and the insurance company wants to appeal to the High Court. It is a mandate of the EC Act that any appeal before the High Court shall be accompanied by what is called as a certificate of the commissioner to the effect that the amount is deposited. And there, that is the section 30 of the EC Act. So 30 of EC Act says in very clear words that I'll just read the relevant section only. The commissioner shall issue certificate of deposit of commission, deposit of the amount of quantum by the appellant to file appeal before the High Court on section 30 of the EC Act. Appeal shall lie to High Court on any order passed by the commissioner. We got so many headings, and the time limit is 60 days from date of the order, and the proviso to section 30 clause 1 says that provided further that no appeal by an employer under clause A shall lie to High Court unless the memorandum of appeal is accompanied by a certificate by the commissioner to the effect that the appellant has deposited with him the amount payable under the order appeal against. So 30, subclause 1, proviso says deposit the amount and take from the commissioner a certificate of deposit, in which the High Court will not even number the MFA filed by the insurance company or owner as the case may be. That is 30, clause 1, proviso to the EC Act.
To what extent the EC Act has removed the earlier ambiguities which were dragging in the decisions or case to be filed in upper courts to get the right decision? He says, what were the fallacies in the Workmen Compensation Act which have been done away by the Employees Compensation Act?
Now here they have just for the word workman, the word used is employee, and they have also added some important changes, but the changes is very minimal, because they have given a big list now. Now the list runs into as many as 49 different types of persons who are now called as employee under the provisions of the EC Act. So section 2, subclause DD of the Act defines what's called as employee. In schedule 2 to the EC Act, they are given list of persons who will be called as employee, and there they have described various sets of occupations which would qualify those employees as employee under section 2 DD of the Act. They have made, a big list of 49 persons, 49 occupations, and those employees who work in those units, they are covered by the provisions of EC Act. So they have widened the net of various professions, various trade or businesses to bring in the fold of the EC Act. They have widened the scope of number of occupations which are added now to the EC Act by amendment in 2010, wherein they changed the word workman as employee.
Are the employees not covered? And if the employee is not covered under the ESI Act because of the salary, that is the upper limit cap, can he claim the compensation under the Employees Compensation Act?
See, I have given the case law of the apex court, direct case law on the point. Employee insured by the employee under ESI Act, he cannot maintain a case before the commissioner under the EC Act. And the decision is of the Supreme Court of India. That is, I have given the case law of Supreme Court of India decision. I'll just tell once again the relevant, ratio. I think I have covered the case law on the point. That is Drupada Bai versus Technocraft Toolings 2015 part 14 SCC page number 454, 3 of EC Act, 53 of ESI Act. Once an employee is an insured person under 214 of the ESI Act, employee or dependent cannot claim compensation under the EC Act. That is 2015 part 14 SCC page number 454.
This is by Fayaz Khan. Are the defenses under the Motor Vehicle Act, like driving license, permit, etc., applicable to the proceedings under the Employees Compensation Act?
Yes, sir, very sure. We got here the latest case law of Supreme Court of India. That is Bailey Ram versus Rajinder Kumar. That is edition of, September last year. That is 23/9/2020. Still not yet reported. There is unreported edition. In this case, the facts of the case are that driver of a truck suffered injuries in the accident, and he approached the commissioner for grant of compensation. The owner appeared. He filed objections saying there is insurance policy, it is covered. The insurer filed in the court objections saying that DL of the driver had expired more than 3 years ago. Accident in this case took place, and that driver drove the vehicle like that, without license for more than 3 years, and he suffered injuries. And he approached what's called as the commissioner for compensation. The accident was on 20th May, that is 1999. Deal expired on 6/9/96. So for nearly 3 years, he was driving the truck of the employer without DL. In this case, the apex court held that the employer is liable and not the insurance company. The ruling of the Motor Vehicles Act, pay and recover, in this case was not applied. As you all know, DL is not there. Okay, DL had expired. What the apex court has passed orders in many cases, the insurer, you pay the amount to the claimant, recover from the employer. But here the apex court held that owner is liable, but not the insurance company. In this case, the trial court allowed petition, asked the insurance company to pay the amount of quantum. Insurer appealed to the High Court, and High Court told that the company is not liable to pay the amount of compensation. So this order of High Court was confirmed by the Supreme Court of India in the case of Bailey Ram versus Rajinder Kumar, civil appeal numbers 7220 and 7221 of 2011, disposed of by apex court on 23/9/2020. DL not renewed for 3 years. Company is not liable. Owner to pay the amount of compensation. In this case, Supreme Court of India did not apply its ratio in the context of ME Act, National Insurance Company versus Swaran Singh, 2004, Part 3, SCC, page number 297. The claimant in the Supreme Court, he just pressed into service the decision of Supreme Court of India. In the context of ME Act, the apex court held that we cannot apply the case law to the facts of the case on hand, and it held that the company is not liable and the owner is liable to pay the amount of quantum.
We have taken all the questions which were posted, and it was quite an informative session, and I'm quite sure that the doubts regarding the Motor Vehicle Act's choice of election under the ESI as well as the Employees Compensation Act, as to how they are juxtaposed, how there is a difference of the jurisdiction, they will be able to understand. And to all the friends who have been connected with us, we are thankful to encourage us and keep on sharing, liking, and commenting upon our YouTube channel. Thank you, everyone. Stay safe, stay blessed. And before we part for the day, again, though it's a Father's Day, I would say that every day of the parents is a day which we should cherish, celebrate. And they say this is the only one of the only real relationship where they may not say I love you, but still they continue to love you. So keep loving your parents, and that's the way to grow in life. And everyone stay safe, stay blessed, keep on getting yourself vaccinated, stay safe, stay at home. Thank you, sir.
I thank Sri Vikas and all the viewers. And for me, I was made to read once again. I read it quite some time back. But to update the law of the point, I just thought, and today I had a full exercise. I got today only the ruling of Bailey Ram versus Rajendra Kumar. Still not reported in the SCC. I just checked also, but it's an opportunity for me also to reread and acquire more knowledge. I'm very sure that Sri Vikas will take forum to a very higher level. And as it is now, he is very active in the court also, and also in these organizing webinars. And as I know personally, organizing function is very, very difficult than appearing for a client in a court. And he does both with compassion, and he is a very happy man. And he has wished all of us happy Father's Day. I'm very sure that we will take care of our health. And I thank once again the viewers because they were very patient and there was no interruption in the middle. And what little I had gained, I have shared with you. So thank you very much. Namaste.